Good afternoon, everyone, and welcome to the latest in our current series of Planning Live webinars. I'm Amy Harley, a solicitor in the planning team here at Brodie's. I'd like to welcome Neil, Karen and Victoria from our planning team at Brodie's to provide some practical insights into the use of Section 75 agreements. Today's topic is particularly relevant against the backdrop of ongoing consultation in relation to Section 75 agreements. The Scottish Government launched their current consultation on resourcing the planning system back in February 2024. And as part of that consultation, they asked for views on the proposal to introduce a model Section 75. The consultation focused on standard clauses covering a range of matters, such as excluding liability for former owners, ultimate owners and statutory undertakers, and registration of planning obligations to be used among planning authorities. Consultation responses were published in August 2024, and the Scottish Government is continuing to consider next steps. Throughout today's discussion, we will also draw on our experience from negotiating Section 106 agreements to consider what lessons can be learned from practice south of the border and vice versa. We have a lot to cover today, so I'll get right into it with a question for you, Neil. We don't see unilateral obligations being used very often. Can you tell us why that is?
Yeah, thank you, Amy, and good afternoon, everyone. They're called unilateral because they're not signed by the planning authority. If there's only one landowner, signed by the landowner, if there's a landowner and developer, both of them signing, etc. But the important thing is it's not signed by the planning authority. And that's actually the key to why they're not used all that often. So just to explain the why of that, if you're negotiating the Section 75 in connection with a planning application, you have to satisfy the planning authority on the Section 75 before they'll issue the planning permission. So there's not much point doing it unilaterally because if you put forward in your unilateral a position the planning authority don't feel is appropriate, they'll just say no. So if you're negotiating with them anyway, you're as well getting them to sign it in the normal way that we do with Section 75s. So the situation where we come across unilaterals is occasionally when it's part of an appeal. And in Scotland, the practice is that the reporter would issue a minded to grant decision saying, I'm going to uphold the appeal, but for reasons stated, there has to be a Section 75. These are the heads of terms. And depending on the cooperation you're getting from the planning authority, in that situation, you might see advantage in doing a unilateral because you have the opportunity to persuade the reporter that your unilateral is acceptable, even if the planning authority don't like it for whatever reason. Another issue, though, is because the unilateral doesn't include the planning authority as a party, that means you can't put in cross obligations requiring the planning authority to do things because they're not a party, they've not agreed to it. We're not very clear about how far that would go because there's not been any litigation on this. But to give a practical example to illustrate the uncertainty, within the typical bilateral, multilateral Section 75, if the developer is agreeing to pay a contribution towards schools, typically the Section 75 will require the planning authority to use that money within 10 to 15 or maybe even 20 years these days. Otherwise, they have to give the money back. In a unilateral, because the planning authority aren't a party, if you included that use it or lose it, as it were, there's a question mark about whether you could enforce it. So if you were wanting to be really sure that your unilateral only covered things that were truly enforceable, you just couldn't require the planning authority to do anything. So that's a major limitation as well. So those are a few of the reasons why, although we quite often get queries from clients, oh, could we use unilateral? When you actually explain through, in most situations, you end up just reverting back to the usual scenario.
I think that last point, Neil, isn't well understood. I've certainly seen people presenting unilaterals where they have included obligations on the planning authority, and as you say, it's with the council not signing up to it, how does that work? And I think people just aren't familiar with the setup. I mean, one possible way of tackling that is having contingent obligations that you might say, well, my undertaking to do X is subject to the following, but that could become awfully complicated if you're having to build in all that conditionality to obligations, and then, as you say, begs the question, well, why not just do it in the traditional way to start with, if you're really needing the comfort of having something that will stick to the council at the end of the day.
Thanks, Neil and Karen. So with that background in mind, let's turn to Section 75 agreements themselves. Victoria, I think we can agree that the complaint we hear most often is about how long it takes for Section 75s to complete. Can you talk us through the reasons for delays?
Yeah, thanks, Amy. So I think before we get into the reasons, it's useful to have a wee look at the stats, because you're right, certainly that's the number one question that clients ask us whenever we're getting instructed is how long is it going to take to get this Section 75 agreed,
and more importantly, how much is it going to
cost? Quite right, Neil, quite right. But certainly on timescales, our starting point would tend to be 3 to 6 months as a sort of conservative estimate for your standard straightforward cases. Obviously, with quirks in both the development and the site, you would be maybe adding on, but 3 to 6 months would be the starting point. And certainly that position is borne out by research that's been done down south in England by the Home Builders Federation, which looked at average timescales for getting Section 106, obviously the English equivalents, concluded. And frighteningly, for 2024-2025, the average was 515 days, which is a good bit longer than our 3 to 6 months. Certainly makes that look quite reasonable, which was an increase from the previous year of about 10 to 15%. So not the best start. The worst, in terms of the maximum timescale recorded, was just over 7 years, believe it or not one of ours, you'll be pleased to hear. And the quickest was 192 days. So again, our sort of average for your straightforward site of 3 to 6 months is starting to look quite reasonable in that respect. I think we have had occasions where we've managed to achieve a quicker turnaround, Neil. I think you've had a good news story.
I thought it was useful just to give it a bit of a broader context, because it's possible to always be a bit pessimistic. And I think this is probably our best ever. And it was for a developer client who wanted it very quickly. And as a result, they're a very knowledgeable client. So we were able to agree a way forward to just have a narrow focus, and we got a very good collaboration with the council team. It was Section 75 in connection with a residential and student development, so a fairly big commercial development, but not the most complicated. We were instructed on 15th May. Section 75 was done and the planning permission was issued by 26th June. Which was a fantastic effort by everyone involved, including the council team. But what I would say is, if you're thinking, come to Brodie's and we'll do it in 6 weeks, a lot of planets had to align to make that happen. So the point we're really trying to make is, we will normally say 3 to 6 months, just to be realistic. Sometimes it can get done quicker than 3 months. Sometimes, obviously, at the other end of the scale, it will be longer than 6 months. it is a bit unpredictable, but sometimes it can be done reasonably quickly.
It's probably worth saying that when a council issues their minded to grant, they will issue it with a sort of warning, as it were, that the agreement should complete within 6 months, or it may have to take back to committee, and that threat is sort of sitting there. Typically, if the council is satisfied that good progress is being made, if you're getting up towards that 6 month time scale, they will agree to an extension. But that gives that kind of indication of it's not unusual for it to need at least that time.
Thanks. All some interesting contrast there at different ends of the scale. Victoria, can you talk to us a little bit about the issues behind the delays?
Yeah, sure. And I should say you'll notice an emerging theme through some of these issues that had people got their ducks in a row a bit earlier, it's possible to overcome them, just to sort of highlight the positive aspect. But Amy, you're quite right. There are a number of reasons that we see cropping up time and time again for delays. The first is the fact that the Section 75, to be enforceable against successors, successive owners, is that it has to be registered on the land register, and so it has to be a formal conveyancing document, which in turn needs the underlying title to all be in order to make that happen. So if there are any problems with that, and obviously often we're dealing with development sites either rurally or in urban locations, that often contributes to problems that need to be fixed. The fact that they are registered on the land also means that we're dealing with negotiating with landowners who understandably have their own interests to protect. So all that adds to the time. And as I say, if there's some front loading and pre-planning in that, those things can be navigated more smoothly. And that is borne out despite the figures that I was talking about earlier. Certainly in England, the registration process does tend to be a lot quicker because they are local land charges, which are just registered by the planning authority, which requires far fewer formalities. So that aspect is quicker down south. Secondly, the other thing we see is just a lack of experience on all fronts, and again, from all parties who are negotiating the Section 75. And to be honest, that is understandable. Planning is an evolving picture in terms of new developments, new types of developments coming forward. Often we're all left scratching our head as we think, how on earth are we going to capture these obligations in drafting, and also with policy positions. We're now all familiar with MPF4, but certainly, as new plan policy comes forward, we have to factor that in.
And just to give a practical example that we came across, one of our clients being a landlord and was approached by the tenant to consent to the Section 75. And it was quite clear the tenant thought that was a complete formality and hadn't thought about it until right before the end of the council's period, and couldn't then quite understand why, on behalf of the landlord, we were saying, well, you'll need to give us a fees undertaking because we need to review the agreement, and we'll not do that until you give us the fees undertaking, and then we'll advise our client, and only then will we say whether or not we've been instructed on behalf of the client to agree that they will sign. So it's things like that, going back to what Victoria said, it's just that lack of experience that people who have been through that sort of process before would know you've got to approach the landlord early in the process, even if you maybe don't have a draft ready for them to look at, so they at least know it's going to be coming, and you can find out, well, they need a fees undertaking, I'll sort that out so it's in place. So there's a lot of things, as Victoria was saying, you can do to get your ducks in the row if you know what you're doing.
And I think that's the perfect analogy, Neil, because it is about keeping all the plates spinning. On the one hand, you've got the landlord raising an issue. I think the other thing we see is that just developing as a whole is a moving picture. So often we're, particularly in this economic climate, we're pausing to reassess viability. Do we need redesigns of development in order to make things work, which then trigger further applications and again are feeding into the delays that we're experiencing, all for good reasons, but they're still happening and need to be dealt with. Equally, from the planning authority's perspective, there can be delays there. Often resourcing is an underlying cause, which, obviously there's only so much that can be done about that. And I suppose finally, I guess just from both the planning authority and the developer perspective. It's the agreed heads of terms and the quality and level of information that we get out when the initial request for a Section 75 comes in. If key points like the phasing and the triggers for obligations have been parked, those will inevitably need to be revisited because they're the real touchstones from the planning authority's perspective, but from the developer's perspective, they also require the money to be pumped in and so need to be agreed. So
yeah, I think for me that's one of the key issues, in that the money is usually agreed by the time it sort of hits the legal stage, but the timing hasn't been, and that's when that's where the arguments can pop up.
Absolutely.
Yeah.
Okay, thanks, Victoria, and Karen, and Neil as well, for your contributions there. Karen, given how lengthy the process can be, I think some of our guests might be interested to know whether there are any alternatives to using Section 75s.
Sure, and there certainly are, but whether or not they can be used will depend on the particular requirement that the council is looking to impose. And certainly the Scottish Government circular on planning obligations does make it quite clear that use of planning obligations should really be regarded as a matter of last resort. So you're really working through a hierarchy of options before you get there. So the first option that should always be considered if there is a requirement is, can conditions be used? And that will include so-called Grampian conditions, as we like to call them, so a negative suspensive condition. And by that, I mean the typical sort of condition that we see, so no development may occur until X has happened. That can be a good way of dealing with requirements on third-party land outside of the applicant's control. So Grampian conditions don't positively require an action to take place, but how they work is that if the developer wants to commence development or allow occupation or whatever it is, then they have to do the action that the council is looking for. One of the big issues with conditions, though, is, as we know, can't require payment of money. So when it comes to developer contributions, then you need to consider another mechanism. But having said that, we have seen over the years that conditions have slowly started to be used in more situations than historically would have been the case. And one example of that would be in relation to restoration bonds, in that certainly Scottish Government, and when it's dealing with energy developments, will deal with those by way of conditions. So it can sometimes be useful to look at Scottish ministers' decision notices, either on appeals or, for example, on Section 36 consents, to see where they have used conditions and also the wording that they have used, and that can give you ammunition as to if you're having an argument with the council about, is a condition appropriate. But the next option, if conditions can't be used, is to consider use of a Section 69 agreement. That's Section 69 of the Local Government Scotland Act of 73. Now, these types of agreement are cheaper and faster because there's no requirement to bind the land. So you were talking, Victoria, about the need to register against the title. You don't do that with a Section 69, so you're not worrying about the same conveyancing formalities. But because they don't bind the land, and so they don't bind successors in ownership, then they're not suitable where they relate to obligations which have to happen in the future, so delayed or phased payments or other future obligations. If a council was to use a Section 69 in that sort of situation, they would release the planning permission, then lo and behold, site is sold and they don't have anyone to enforce against. So for that reason, typically we see Section 69s being used in relation to smallish payments where the developer can commit to pay up front. Developer saving money on the Section 75 process itself. And really the Section 69, it's almost acting as a bit of an audit trail on the fact that that payment has been made. So the payment is made before the permission is actually being released. It's almost like a glorified receipt, I think, in these situations.
And that is actually a situation we've had, isn't it, where the developer said, well, can I not just going back a while, take the cheque to the council? As you were saying, we've said, well, Yes, but the council want the audit trail, so we do the section 69.
Yeah, that's right.
It's a reasonably straightforward way of getting it all sorted.
Certainly in Glasgow, the city council use them quite frequently for their sort of open space requirements, but other councils do as well. So having said all of that, Section 75 should really only be needed when these other options have been considered first, and there's a good reason to reject them. And so you may find that there's a discussion to be had with the council about that. It's probably worth saying as well that we shouldn't be having obligations that are covered off in conditions and planning obligations. We don't need to take a belts and braces approach, so it should really be one or the other, and not both.
Yeah.
And there are some instances where on appeal, Scottish Government reporters have made that point, particularly in relation to occupancy restrictions, where the council have been saying, we're just not sure that a condition is enforceable enough. And the reporter said, well, as long as it's enforceable, going back to what Karen started with, the guidance requires me. And one of the interesting points, I suppose, tipping into residential conveyancing is a Section 75 would appear on the title, so it would be very obvious when a purchasing solicitor is then reviewing title and reporting, a planning condition restricting occupancy might not come up. So you can see why, on a very practical basis, a council saying, well, we would much prefer the Section 75, but that's not what the Scottish Government guidance says.
That's right.
I think that's the thing with conditions. We want to use conditions and rely on them, but you want the confidence that they're going to last, be enforceable, and the sort of standardisation process in terms of discharging them, so that you're comfortable that it is going to work. Obviously, the points you're making about Section 75.
Okay, thanks everyone. Good to know that there might be alternatives in some circumstances. I mentioned earlier that stakeholders are currently preparing a standardised form of Section 75. Neil, do you think that this will be helpful?
I decided in answering questions, I'm going to be positive because it's so easy to come up with problems. Yes, and in mainstream property practice, we're specialist planning lawyers, but from speaking to colleagues, in Scotland, there's a group of lawyers called the Property Standardisation Group, PSG for short, and through the years they have produced a series of standard documents, and you're not obliged to use them, but through practice they have become widely used. And that experience shows the value that you have a starting point. Not every transaction will necessarily work. It might need tweaked a bit, but having that starting point is really valuable. And that's certainly been the experience working with planning authorities in Scotland who have model agreements, they call them. It's the same thing. Edinburgh Council, for instance, have theirs published on the website. So if you've not done one with the Edinburgh Council before, again, this is the ducks in the row point. You can go and look and get an idea. The thing, obviously, is these things are never cast in tablets of stone. There has to be some flexibility. But I still remember at university being taught, you don't you don't change somebody else's drafting just because you would do it a different way. You should look at it and say, does it do the job? And if it does the job, you just shouldn't change it. And I think that's always the difficulty for lawyers, that it's very easy for us to look at something and say, oh, I could do that so much better, or I don't like that, or. But it's just forcing yourself to look and say, well, do I really need to change that? So yes, it's great to have that starting point. And again, if you want to find things to criticise, the difficulty with Section 75 agreements, there's a whole range of situations they're used for. That's one of the reasons why they're useful. If you're doing straightforward payment obligations, payment to the school, payment to the roads, etc., a standard template will generally work. If you're doing something a bit different, it might not. And what's going to be interesting to see in the work Scottish Government and other stakeholders are doing is how they address affordable housing, because different councils have different approaches, and whether they will build in a few different options and try and come up with a standard approach, or if they're just going to park that and say, that's the bit you'll have to do yourselves. We'll wait and see on that.
I think that's difficult because obviously the approach taken is in some way going to link to how affordable housing is delivered in that area, yes, which is a substantive issue. So there's probably good reason why different approaches are taken to the drafting. But also just sort of illustrates the point that for different sorts of development, different authorities have a different approach to the sorts of obligations that they are looking for. So that again will be a point of difference between different areas. So for example, Glasgow will take a different approach to PBSA developments than Edinburgh do, perhaps the same for BTR, etc., etc. So those are differences of substance, not just tweaking perhaps boilerplate clauses about, you know, how this agreement will be registered, etc. It's difficult to imagine that we will see much of a difference in that respect because those points of difference will remain.
Yeah, too many permutations.
Yes.
Yeah, I think so.
But to end on a positive, something is better than nothing. It's much better to have that starting point, the template, the model, whatever we're calling it. And yeah, it might not work all that well in some situations, but it's still better to have that as a starting point to then work from than having that blank sheet of paper, as it were.
I think you're right, Neil. Even if the conveyancing aspect of Section 75s could be relatively standardised, that would take one issue off the table and leave us to focus on the planning obligations.
Yes.
Okay, thanks everyone. Definitely reassuring to hear some positives and to know that it might be helpful for dealing with straightforward obligations in particular. Victoria, what about large or mixed use sites? Do they require a bespoke approach?
The short answer is yes. But we've got time to fill, so yeah, let me elaborate. Yeah, and I think there's a lot of overlap on this issue with some of the delays and the reasons for those delays that I was talking about earlier, because obviously there's a big push from a placemaking perspective to have mixed use developments. It's what people want. But what comes with that is that mixed use sites tend to have more than one developer because they've got more than one use. Coming from different sectors and so different priorities and expertise. On the other hand, individual developers rarely want their own obligations to be contingent on another developer's obligations. So, for example, a developer of open market housing does not want to be limited by the completions that they can undertake because the requisite affordable housing is not up to speed. So, fundamental problem on that respect, which in turn is at odds with the planning authority's key objectives, understandably, which are the security of the obligations in the first place, and secondly, that those obligations are actually going to be delivered at the time that they need them to be. So lots of competing interests on the table, all legitimate interests and priorities, but they need to be managed. And just to add to that, in order for the development to actually happen, it needs to be fundable in terms of lenders being comfortable with what is required and being willing to invest. So lots going on there that a Section 75 is trying to cover off.
It just makes the point, Victoria, that it's not we sitting here as the planning lawyers, but to tackle one of these agreements properly, you really need to understand the whole of the deal, the transaction, what how the contract is between these various, if there are a number of parties behind the scenes, how that all works.
Yes.
So
and to some extent what might happen in the future.
Exactly.
Because
building in that flexibility.
Quite often you might have a situation where initially it's one applicant who's then looking to sell to the multiple developers, as Victoria was mentioning. but they might not know how that's going to work through. Or there might be some need for flexibility. So it can be quite a challenging, it's almost like that 3D chess thing. Is that Vulcan chess?
Yeah.
Where you're just having to think about lots of different variables and trying to maintain that flexibility. But then going back to what Victoria said, ultimately it all comes back to the planning authority needing to be sure that what they want out of it, they are going to get.
Yeah.
And there's not going to be a situation where 3 years down the line, it's not worked because of the way the site has been developed out, and all of a sudden there's part of the site that isn't bound for some reason. And that's why these Section 75s are definitely not the 6-week ones.
Yes.
6 months can be challenging because it actually does just take quite a lot of thought and discussion.
Absolutely. And there is an element of compromise because there is no magic wand in this process to give everyone what they want and need. I think with a view to being positive, the best we can do is almost work backwards. So the end goal is development, thinking, again, working backwards, what transactions might we need to go through in order to get there in terms of what might we be selling off to other parties? What is the indicative phasing programme in terms of construction and from the practical side, and does that align with both the requirements of conditions and the triggers that are being discussed in the heads of terms for the Section 75? Do they align to a reasonable extent that makes things possible? To the extent that we can't get the perfect picture from the start, can we future-proof the Section 75 to take account of subsequent minor planning applications, a Section 42 or a non-material variation, for example, that slightly alter the planning application and the development, but don't otherwise impact upon the obligations that we're delivering to the planning authority? Liability is also a key issue there in terms of, understandably, as we say, the planning authority needs the security that the obligations will happen, but developers don't want to be necessarily liable for someone else's obligations. Can that position be signed up to and then otherwise altered by the development agreement or by some other means? Again, it's thinking outside the box to try and make the development happen. As I've alluded to, it's not always possible to carve up obligations and liability so that one Section 75 then neatly splits off to reflect the mixed uses on a site. I actually have an example that is an ongoing transaction for a site in Midlothian, where a housing development is now in the hands of 5 different developers who all coincidentally are pursuing Section 42 applications to remix the site. And as a result, there needs to be a modification to the Section 75 to take account of that, with all 5 developers and the council cooperating together. Now, so far, we've had a proactive approach from everyone, but it just goes to show that the intricacy that can arise in these mixed-use sites.
Pretty complex, yeah.
Absolutely.
And that's not going to be a 6-week one either, is it?
It's not. I'm going to say that it's gone from weeks to months to pushing a year, notwithstanding there's a proactive approach from everyone on board. So again, trying to remain positive, but yeah, these things take time.
Okay, great. Thanks for that. So Victoria, you touched on modifying a Section 75 there. Karen, can you tell us a little bit more about changing planning obligations once they're registered? So how do you vary them or get rid of them altogether?
Yep, absolutely. So there are 2 ways to either modify or discharge a planning obligation. So state the obvious. The first is by agreement. So really just entering into a minute of agreement with the council, or secondly, by submitting what is really a statutory application to the council requesting the particular change that you want, or if it's a discharge. And in that instance, the council then considers that application and a decision notice will be issued in due course. And both of those methods are provided for in the planning legislation. I think sometimes people think that dealing with it by agreement is just a sort of informal, almost under the radar way of doing it, but both those ways are legitimate under the planning legislation. So how do you decide then which method you would use? Well, If the council's on board with the change that you want and doesn't insist on an application being made, then usually the agreement route is going to be quicker and less work. The minute of agreement might even be very short. I've got one at the moment where we're literally changing one word within an agreement, a figure, unsurprisingly, or it could be more complex, a number of different clauses. But if the council isn't keen on the changes that you're wanting to make, or they're maybe just not engaging with you particularly quickly, then you can always submit an application. Now, the good news is there's no fee to do that. It's completing a form, and usually you'll set out a statement giving the reasons for the change that you want to make. But the good news is that if that is then refused, you've got a right of appeal to the ministers, so you can take it out with the council. Statutory applications can also be useful if, in an instance where there were perhaps several parties to the original agreement, and one or more of those parties won't agree to sign up to the variation that you want. If you go down the application route and the council grants the application, then you can register that decision notice, assuming it's been prepared properly by the council, and register that directly on the title, and you don't need the approval of those other parties. So that can be very useful. As I say, two caveats to that. You need to have a registrable decision notice. Some councils don't produce them in a registrable format. But secondly, you can't have a modification that increases a burden on a third party. So to give an obvious example, you couldn't say, well, I want to reduce the amount that I've got to pay, and Victoria can pay extra instead. The council obviously couldn't grant a modification like that unless Victoria agreed. So sometimes those situations do arise. But the application process can be quite flexible. The council can end up granting a modification if it's sort of on board with what you're wanting, but maybe is reaching a compromise with you. It can grant the modification in slightly different terms to what you asked for if you agree to that. So that's an improvement on the position from when a modification was initially introduced.
And an interesting difference between England and Scotland, and it's something that surprises a lot of people. In Scotland, you sign the agreement and then typically the planning permission gets issued. There's nothing to stop you at that point applying to vary the agreement. In contrast, in England, there's in effect a 5-year lockout period. So once you've signed the agreement, you're stuck with it for 5 years. So that's certainly a very flexible situation where for whatever reason you decide, I'm just going to do the deal with the council, but you might then want to apply to tee up an appeal possibility to get it in front of a reporter if you feel that you want to have a second bite at the cherry.
Yeah, absolutely. And of course, there's always changes in circumstances that just something that people didn't anticipate at the time, causing the need for it to be reconsidered.
Yeah.
Okay, great. Thanks. Before we run out of time, one final question for you all from the Q&A box. What might be coming down the track in relation to Section 75s? What should we be looking out for?
Well, something that I've come across just in recent times, but I can see there being more of it. It's in relation to large infrastructure projects, particularly in rural locations, as is often in the case. They've got long build-out period, and the question of accommodation for construction workers can arise. It can cause a concern for local authorities where those construction workers are coming into an area and having an impact on the availability of housing locally, or indeed tourist accommodation. So I've seen that question coming up in at least one case that I've dealt with, and the particular council was looking for mitigation of that impact through an agreement. We had quite an interesting discussion about what sort of agreement that would be, but there's some precedent for that down south in relation to some of the nuclear developments that have come forward or have not come forward, but were consented. So that's one that I think we could see more of with all the electricity infrastructure, for example, that's in the pipeline.
just sticking with the resourcing theme, again, subject to underlying policy position, but I can totally see developer contributions being sought for things like nursery spaces at one end of the spectrum, obviously massive resourcing issue there, as well as individuals' ability to pay for that. And then I guess at the other end of life with care home spaces and sort of infrastructure to support elderly as people live longer, I think, that's something that developers will be asked to provide potentially in the future, something to watch out for.
It's a great question, because certainly what I've seen, the difference from when I started, initially, Section 75s were very much just about improving roads, basically. Does your housing development need a roundabout? And through time, more and more has been added to the list of things that might be mentioned, particularly in terms of asking the developer to provide financial contributions. And as both Karen and Victoria have mentioned, there's all sorts of things possibly down the line that people might think of. There is no closed list. The only thing within the legal requirements is the Section 75 must always have a planning purpose. And as we know, planning is quite a broad church, so it's not much of a restriction. In terms of my example, I was very interested working on a Section 106 in England recently, and it was viability assessment provisions around affordable housing. So it was acknowledging that viability is very much a moving target, and it is the nature of a lot of property development, but particularly housing, that you're not necessarily going on site the minute your Section 75 or your 106 is signed and the permission's issued. It might be 6 months, it might be a year, it might be 2.5 years. So it's building in that flexibility rather than necessarily going with a variation application. Yep. And I suppose actually it's picking up on that 5-year lockout point. In England, you've got to build in the provisions, but it's also providing a framework in advance and saying, well, if you want to come back because your viability has changed and you want a negotiation, this is the framework that we're going to be looking at it. So you've got that certainty. So I think that's the kind of thing that we can see possibly coming in the future.
Thanks, everyone. Well, I think that's us almost out of time for today. Some really interesting discussion there. Before we let you all go, if I can just give a plug for our next Planning Live session, which will be after the summer break in September. Further details about that and what we will be discussing will be sent out in due course. In the meantime, if you want to have a chat about any of the issues we've discussed today, please do that. We would be delighted to hear from you. So it just remains for me to say thanks again to Karen, Neil and Victoria today, and I hope everyone has a lovely summer.